Hi, everyone, and welcome to our second section in Module 6, which will be about protecting innovation. We alluded during the course, we alluded to patents and copyrights here and there. Some of the case studies talked about it, but we want to take a closer examination on this topic in the class slides, and we'll also have some additional materials to discuss in the Module 6 overview. So, protecting innovation, you have actually quite a few options, right? And it's not as trivial as just filing a patent because there are costs of protecting your innovation, right? And there are some consequences to do that. Given, and you'll see the statistics in a little bit, given kind of the rise of technology companies in the last 10 or 20 years, we see also a significant rise in patents, right, in patent applications. And so a lot of the battles that we've seen in technology also have to do with who controls which patents or which patent real estate, and how can the firm protect yourself or protect each other, and at the same time, if I want to develop a new technology, how do I use a patent strategically to create a competitive advantage? So I'll give kind of just a general here, like a general example of what this whole patenting and trademarking can really do and why that's important. All of you, we're using MP3s, so the music file format that was developed by the Fraunhofer Institute in Germany, was around 1991. At the time, they couldn't really predict how successful that will be and how important it will be for the music industry. But you all know that Napster, right? So as soon as we have proper digital files that are a certain size, or enough of a size that we can kind of move them around pretty easily, what we've seen is a business model that was focused on exchanging digital files illegally in most cases. And one of the early innovators, so to speak, was Napster. And so Napster provided this free software program. People that were connected to the internet could then essentially exchange these files, right? So if you had a CD or later on a DVD, but you had some music titles, you could essentially convert these .wav files, which were pretty large. You can compress them to an MP3 format, and that would make it a lot easier to share, your music files, especially during the time where broadband was not that common yet. And so that was pretty disruptive for the music industry, right? The music industry for a long time was struggling to figure out how they can actually monetize, how they can actually deal with digitization. And so these peer-to-peer music services continue to rise. What we've seen is essentially not only Napster, but other providers as well, right? And so it took quite a while until the music industry kind of built a business model. In this particular case, Apple in 2003 opens its iTunes store, and you can essentially buy titles. You can buy individual titles that are all typically used in an MP3 format. And this is essentially the rise of the digital music, what they called a distribution revolution, right? That we move from CDs and a vinyl to essentially digital sharing of music. And of course, we continue this, and we've seen Spotify and other services essentially stream music now. And so we, this invention of the MP3 player in 91 actually had significant ripple effects. By the way, the Fraunhofer Institute is making a fair amount of money off licensing the MP3. But what we've seen really is protecting your innovation. In this case, in this case, compressing a file format can actually have both macro level and micro level implications. Now, we call the concept appropriability, but essentially what we're trying to say is we have an innovation and we're trying to capture rents from this innovation, right? Whether it is we selling products, we can potentially license our innovation, right? Like the Fraunhofer Institute did. They didn't really develop their own music service. They are a research institute. But they can actually generate and monetize. They use this money that they got for licensing the MP3 to invest in other innovation projects, right? And we'll talk a little bit later about how universities do that and technology transfer offices. But here the idea is really some innovations are hard to copy, right? And we have they might be hard to copy because they're tacit, socially complex, etc., etc. Remember, we talked about this when we discussed the sustainable competitive advantage. Other innovations might be easy to copy, right? Whether you use like a new chainsaw, for example, right? If you use like a better material or a better way of how the chainsaw moves around, that might be relatively easy to copy. And therefore you need a patent to protect yourself, right? Again, the best protection typically is customer satisfaction, right? And any imitators in the market who cannot replicate your quality will not be as successful as the original, right? We've seen a lot of this kind of imitation patent protection in the drug industry, right? So if you want to buy Tylenol was kind of the first company who packaged acetaminophen, who's kind of a pain reliever. And since then, we see, a lot of brands, for example, Walmart and CVS, etc. They're essentially packaging their own acetaminophen tablets that they point out are equivalent to a particular Tylenol brand. You'll be surprised, even in these kind of situations, customer loyalty is pretty strong, right? Like Tylenol is typically priced higher than these brands at the CVS brands and Walmart brands, and still people buy them, right? So again, we'll thinking about patents and trademarks, etc. At the end of the day, what you're really looking for is customer value, right? If the customer value is strong enough, that is creating a lot of protection on your end. So patents, you've heard a lot about them. You probably had to deal with them in your job. Is quite a significant invention, right? Is a significant administrative / social innovation itself, right? Before we had patents, it was really hard to protect intellectual property, right? Anybody who would come up with a new idea or a new product would get immediately imitated and could do essentially nothing against that. And so patents, especially in a technological, in an economy that's dominated by complex technology, is becoming increasingly strategic, right? And so when you're a startup and you want to bring a new market to new technology to market, we talked about first and second mover advantages and disadvantages. Now you really have to think about the litigation space as well, right? So if you have something novel, something important, you need to protect it, and you also need to have the litigation team to be able to protect it, as we'll discuss in a little bit. Now, there's all types of patents. There's the standard patent is called a utility patent that can protect new and useful processes, machines, manufactured items, or a combination of material. You have design patents, okay? Those have become also relatively popular. And you can protect ornamental designs, for example. You have plant patents that can protect new varieties of plants, and that's been pretty controversial. And in 1998, that was an important step. Software algorithms became eligible for patent protection, right? And you can imagine that Google, Microsoft, all the big and large software companies now kind of have to think about how they're gonna protect their software algorithms. So this is quite significant, right? So the patent system, we talked about that is a pretty important social innovation. It turns out that it's even implemented in the US Constitution. And so it's Article 1, Section 8. And so from the beginning of the United States, protecting intellectual property was a pretty key point that was considered. Inception 1790, okay, first patent July 31st. But of course, since then, which is what, 200 plus years, 200, nearly 30 years, a lot has changed in the patent landscape, right? As discussed, patents have become an epicenter of litigation, right? So patent lawyers have become, they didn't used to be as common or as well paid, but patent lawyers, patent processing individuals, they really have a lot of power in our economic system now, right? Because as patents become so dominant and so important, and litigation has gone up significantly, their position has improved. These are some examples. I mean, there's plenty of websites. You can look at the biggest patent litigation cases. One of the pretty big one was Eastman Kodak versus Polaroid. And Kodak essentially assessed a 900 million penalty. We've also seen a emergence of a phenomenon that's called patent trolls or patent sharks. Individuals or a set of companies that look at the patent landscape and selectively litigate against certain companies, right? And so if they find a weakness in your patent protection or a weakness in your patent, they target you, and they're trying to extract money for that. Again, some of these things are kind of useful. Some of these things are, are kind of a burden for companies. But the important insight here is that landscape has changed significantly, right? And so you as a technology company, if you want to launch a new product, a new technology, a new innovation, that is a really, really important aspect that you have to put into consideration, right? That companies could potentially sue you or trying to sue you out of business because they're using patents to move against you. Now, as mentioned, the total number of patents issued has gone up significantly. So we had about 26,000 around the early 1900s. We have about 300,000 a year at around 2014. The patent process can take quite a while. Again, some of you might be very familiar with this. Takes about an average of 33 months in 2011. That number has kind of fluctuated a little bit, but it's still a significant amount of time, especially for a new business, right? A business that is just about getting started, a new venture that has gotten venture capital or, used their own funds to kind of launch their products. the longer it takes, the longer you have to wait for patent protection, the more vulnerable and the less revenue can actually generate, right? So that time until the patent is granted is quite critical for companies, small companies. Interesting, if you look at some of the statistics, there is a set of companies that kind of dominate the patent space. First and foremost is IBM, followed by Samsung, LG, Canon, Huawei, Intel, etc., etc. You have, I mean, IBM is about filing or granting or got about 8,500 patents granted in 2021. That's quite a significant amount of patents. You see how important that has become, right, for a technology company or a company in general to be present in the patent space. And these are significant costs, right? Filing a patent is not cheap. Waiting for the patent, trying to protect the patent, etc., etc. So quite interesting how this has evolved. So this is from USPTO, which is the US Patent Agency, and shows kind of, we remember we talked about kind of technological inventions, and this is kind of an overview of how some of the important patents that some of the technologies that have resulted from these patents that have been protected through these patents and how important they were, what kind of impacts they have created. Patent litigation, right? We talk about how important that is. We see that we've seen kind of a little bit of a peak in around 2015, where we have like a significant amount of patent trials. There is some patent cases that won't have court action. There is a pre-trial, after pre-trial, before trial, during or after trial. So what we've seen is most of this is kind of handled before pre-trial, but quite interesting, right? So we've seen really a peak around 2015, and that was kind of also the rise of many of the technology companies that we know today. Now there's a variety, as you can imagine, right? Different countries have, although patent systems are generally relatively homogeneous between different countries, if you want to secure an international patent, you have to you have to go find a lawyer that's specialized for other countries, right? The EU, the European Union, is a pretty large block of countries, or important countries also for selling products and consumers. You have China, of course, that has gone through a major transition in terms of the patent litigation landscape. China used to be well known for not respecting intellectual property, with Chinese firms imitating a lot of the products, a lot of Western products. That has changed, and the Chinese law and the Chinese judiciary has started to enforce patents. Also because a lot of the local companies are starting to get imitated by other local companies, so they have to start. The government had to actually start enforcing these things. Now, there are some conventions that span a pretty large number of countries, one of which is called the Patent Cooperation Treaty. And so they can, in that way, apply to a multitude of countries without going from one country to another. Like, having these conventions kind of helped. You typically still need to consult with lawyers that are specialized in international treaties or international patent protection. But that's been kind of important, right? don't want to go from country to country to country and trying to protect your patent. That can be costly and take a long time. So they came up with these treaties to harmonize some of the laws. Not all countries have been part of these treaties, although some of these might have changed now in the recent time frame, but you see it covers actually quite a large space of the world. Now, there is, as you know, there's different ways of how you can monetize a patent. You can license the technology, you can sell the patent rights, and you can also start your own company, right, based on that patent. Again, when we talked about patent litigation and patent strategy, is often you buy patent real estate to keep particular competitors out of your market, right? And that can be, you know, sometimes successful, sometimes not, depends on how easy it is to defend that patent or circumvent that patent or re-engineer the product. There has been, as I said, we talked about patent trolling. Apple claims that they have been the #1 target for patent trolls. Typically, large companies are, right? I mean, large companies that have big patent portfolios, there might be some gaps, right? And so patent trolls or patent litigation companies, they gonna target these. So you buy these kind of bundles of patents, and this is particularly interesting when big technology companies kind of go out of business or they get into financial trouble. And then you'll see it's kind of blood in the water, and all the big sharks or the big technology sharks, they're going to go and buy all these patent bundles, right? So patent tickets, because they hope that way they can kind of, protect the territory or expand a new territory. And that can be quite competitive, right? So these companies sometimes auction off their the patent portfolio. Nortel is an example in 2011. And this consortium that included Microsoft, Apple, RAM, Sony, and Ericsson kind of bid for them. They were worried that Google will essentially buy this massive patent portfolio and kind of, expand their reach. Again, you'll see this, right? As what's really interesting is that as some companies also change their business model, right? Or they're retracting from certain areas of their business, they can use these patent portfolios as an asset, right? So you can borrow against that asset, you can sell that asset in an auction, and so that can be pretty valuable, actually, right? And so that's become kind of the strategy of these big technology businesses to figure out which of these patents, these patent bundles could potentially fetch a good price afterwards. Then we have trademarks and service marks. Typically, if you use that mark, you don't necessarily require registration, but they have to be registered before suit can be brought over use of the mark. Okay, so if you want to sue somebody, you have to register your trademark. If you are legitimately using this, you don't need to per se require it. But if you want to operate internationally, typically registration is needed. Again, you have a couple of treaties in this case as well. So the Madrid Agreement and the Madrid Protocol. Okay, so you talked about the Paris Treaty before for patents. This is something similar. We want to make sure that we don't have to go country through country to country and get these things. If these protocols typically cover a big part of the world in terms of patents. Also keep in mind, members that are not, countries that are not members of these treaties typically are not aggressively enforcing intellectual property rights. So then you have to really figure out a strategy of how you kind of deal with that in their local markets. So we see copyrights a lot in, books, creative works, movies, etc. You know that on YouTube, for example, I've had that a couple of times. When I wanted to show a video in one of my online lectures, Google would say, "Hey, sorry, this is copyrighted. You can't really do that, right? You need to get approval by the copyright owner." There is something that's called fair use, okay? And that means that you can use the copyrighted material for purposes such as criticism, new reporting, teaching, research, etc., right? And that can get tricky, right? Like, where does fair use start and where does the unlawful monetization of this starts? So let's say I use a video in my class, or I use a video for educational purposes, but I'm actually getting paid for this class. There have been some cases where that has been contested, right? And the copyright holder said, "Hey, if you use my material and you make money, then that is not okay," right? And so this is kind of, there are some gray areas there. But Disney has been one of these companies that are very aggressive in enforcing their copyright of their movies and creative works, and that's all right. The idea is really, because some of these can be easily replicated, right, or easily used, right? It's easy for me to use a movie clip with the tools now, the digital tools that I have. I can cut and paste a clip out of their movie and use it for monetization purposes, right? And so that's tricky. And because a lot of copyright is being challenged by digitalization, the owners of these copyrighted materials have become pretty aggressive in terms of enforcing their rights. So, yeah, copyright varies from country to country. Here you have what's called the Berne Convention, that there is some kind of a protection. You can kind of do the same thing as you could do with patents and trademarks. But again, right? So the issue is less whether you can file a copyright. In many countries, the question is, how do you enforce your copyrights, right? And that's often the tricky part in these circumstances. Sometimes the best way to protect your secret is to not protect it at all, in the sense, right? So in many cases, companies are not going to put their software algorithms and not trying to patent their software algorithms, because software is so easy to copy that it makes no sense for them to do that. It's a lot better if you don't know actually how the company is doing this stuff to begin with. Coke, for example, never patented their formula for Coke, because they realized that there's probably an easy way to circumvent that patent, and they would give up their formula. They would essentially make their formula public record, and so they didn't do that. Again, trade secrets, you have to protect them, right? So you have to find processes and ways of how to avoid people or individuals, let's say, within your company, to kind of publish these trade secrets. So that gets kind of tricky. There are kind of ways to do that. Again, the idea of a trade secret is really that your best protection is your business model and your relationship with the customers, right? The value you create for your customers. If you think about the business model canvas and the value proposition, the best way to do that is that, right? You can hide behind patents all you want, and trademarks and copyrights. But the idea is that at the end of the day, if the customer value is right, those things are essentially just a backup or an insurance rather than an active strategy to make money. Again, so effectiveness and use of protection mechanisms, some industries it's more effective than others. Pharmaceuticals is incredibly powerful, right? So patents in the pharmaceutical industry are really, really powerful. And so that's why the approval process is also pretty rigorous. Granting that protection is not trivial. The FDA goes through a lot of effort to prove the efficacy of these drugs and the safety of these drugs. So when they grant somebody this kind of protection, they know that this is not for nothing. Again, other areas like electronics, this might be invented around. That's what we call it. And so it's kind of when you're operating in that industry, you have a lot more experience. And so you can have a better understanding of what patents can do, or some these legal protection mechanisms can do for you. Manufacturing processes and techniques are hard to patent. Again, sometimes diffusing the technology is most important. We've seen this in a few examples. I think Volvo did this with their safety belt. They weren't aggressive in protecting it, but they essentially made it open for everyone to use. And that has some real significant impact in terms of safety, right? So Tesla was thinking about opening up some patents so they can, improve the adoption of the EV technology. We talked about this in open innovation, in the open innovation chapter, right? So often it's really important. It's a lot more important to develop the technology faster, even though I don't control 100% of the equity, because getting it to market, getting it vetted, getting a partnership around the technology is more important than just owning the technology, right? That's not the case for every industry, but in some industry, collaboration and cooperation in terms of intellectual property makes a lot more sense. Example here, so this is an interesting example. So IBM in its early, so in the 1980s, when personal computing started to slowly kind of make a leap forward, they essentially needed an operating system, right? And at the time, Microsoft, who had bought DOS from somebody else and kind of reformatted it to work for them, they kind of partnered with Intel, with IBM, and kind of included their operating system on pre-installed essentially the operating system on IBM computers. That is one of the reasons why Microsoft became so powerful in the 90s and early 2000s. Now, IBM, you saw it in the stats before, is one of the major patent holders in the United States, right? They file a lot of patents and they have a massive patent library. And back in those days, right, when they're trying to compete in the personal computer market, they believed that their proprietary basic input and output system, BIOS, I don't know who's familiar with computer hardware, would essentially protect them, okay, protect the computer from being copied. They were wrong. It turns out Compaq reverse engineered without violating the copyright, and then introduced a computer that was essentially behaving like an IBM computer in every way. And we have essentially other companies who were doing the same thing, right? And so relying too much on your technology protection can just make you sluggish, right? You focusing on your technology protection rather than your business model and your customer value is effectively a losing strategy, because there will always be somebody who will find a way to replicate or circumvent or reverse engineer your technology eventually in some form or shape, right? One example and one important thing, so we talked about the Fraunhofer Institute here, but the Bain-Doyle Act of 1980 was really important. It gave universities the option to monetize or collect royalties on inventions, right, that were funded with taxpayer dollars. That wasn't the case beforehand. And that created this whole spur of technology transfer offices. Universities have a lot of researchers, and those researchers come up with a lot of inventions. Some are more commercially viable. Typically, most of them are not. I remember at Northwestern, when I was there as a grad student, one guy in the chemistry department who invented this drug with a pharmaceutical company. They generated, I think, around $900 to $1 billion royalty of that drug, which is one of the more successful technology transfer stories. Typically, technologies and inventions that are made by universities are not as commercially viable, right? Researchers typically don't look at commercial viability. They're trying to maximize the grant money they get from grant funding agencies. And again, not all these technologies are really that valuable, or the patents that they hold are that valuable initially. Again, the revenues from these, they will vary. Typically, if you're working on drugs, your potential to making a fair chunk of royalties is pretty good, right? That's a really, really good area, just also because patents there are really, really valuable, as we talked before. And this is just an example of the Office of Innovation and Commercialization at Michigan Tech. You will find very similar processes at University of New Mexico, at Stanford, at any of the big universities, R1 universities, research active universities where they have departments that invent a lot of stuff, and they want to patent it or include it in their patent database. Again, we talked about this a little bit in the context of open innovation. We have wholly proprietary versus wholly open system. There is ways to think about this, right? Also keep in mind that in the age of ecosystems, on platform ecosystems, intellectual property gets a little trickier, right? So think about Apple and their iTunes or their Apple, their app systems. They have, I'm sure, plenty of patents that kind of pertain to ecosystems and how they run their ecosystems. But it just turns out collaboration in especially complex systems makes more sense than trying to protect the entire system. It's just really, really difficult to do that. It's very costly. It puts the firm in a rather defensive position, right? Because you're focused on defending your patents rather than creating value for the company. And you see, again, there is a couple of examples. You have for wholly proprietary, you can think about Microsoft's Xbox. For wholly open is what's called the glyphosate thing. You have very liberal licensing agreements with Sans Java. You have Microsoft Windows that has both licensing as well as protected systems, et cetera, et cetera. You'll find a whole range of examples for these different kind of categories. Again, it depends, right? At the core, what you're really looking for is your business model, right? If you look at your business model canvas, that will dictate where you want your patent strategy to be in, right? And not the other way around typically. So again, there is advantages to diffusing your technology, right? Opening it up versus keeping it proprietary and therefore potentially maximizing your licensing fees. If this is part of your business model strategy, right? If that's your core proposition of the business model, then protecting your patent makes a lot of sense, right? If you're in the business of licensing technology or developing technology and licensing it, that is perfectly legitimate, right? If you're building complex products that you can yourself not necessarily afford, right? Where you need a lot of partnerships. Think about the Boeing 787, right? Where the patents, where they have this complex systems of suppliers. You can imagine that patenting there gets a little trickier, right? Like who's patent? I mean, the suppliers will patent their processes and their materials. You will patent maybe your assembly systems. But again, right? So this gets tricky. And you know, especially in a digital world, in a digital economy, that gets even more complicated, right? So the idea of how patents kind of function has changed over the last 20 years, also because we have just seen a complete change in business models and in value propositions for customers. Again, these are some questions that you might want to consider. Again, whether this protection, how effective protection mechanisms are, depends on the country, depends on the legal framework, depends on your business model, depends on the resources you have at hand, depends on the competitive landscape, et cetera, et cetera. This is just giving you kind of a broad overview and some critical questions to think about. If we're going to have a patent, right? If we want to develop a patent to protect our technology, what should be our strategy, right? Like how do we position ourselves and how do we integrate that in our business model? All right, that concludes the second section of module 6. I hope you enjoyed that and feel free to send me any questions and concerns you have. Bye-bye.